So firstly, I'd like to thank Mr. Mohammed Mukhtar and the Maat team for organizing the event, as well as the esteemed panelists for bringing forward such an important and timely topic. And thank you for the participants as well who are attending. I'm Basant Abdel-Meguid. I'm a regional legal advisor for the ICRC. I work in the regional IHL unit, covering the Near and Middle East in ICRC. I'd like to thank Mr. Fadi. He provided a roadmap to start the discussions on the ATT. I'll focus on the IHL element more and the humanitarian aspect perhaps. So as you all may know, we continue to witness an increase in the number of armed conflicts around the world, be it international or non-international in nature or other situations of violence. We see that humans continue to bear the burden and civilians continue to endure the worst form of suffering. And obviously, we have a lot of vulnerable groups that stem out of this, which includes the dead, who are usually forgotten, the wounded, people deprived of their liberty, which includes prisoners, detainees, missing persons. We have refugees, displaced persons, and the list continues, unfortunately. And this does not even include the destruction and devastation to civilian objects, which includes fields, properties, lands, schools, hospitals, cultural heritage, and more. And given the mandate of the International Committee of the Red Cross, or ICRC, and our work in the field and our mission to protect and assist victims of armed conflict and other situations of violence, we do continue to witness the heavy human cost caused specifically by the widespread proliferation and misuse of conventional weapons. We see that such steady supply of arms, ammunition, replacement are one of the key factors responsible for exacerbating these humanitarian consequences, as well as increasing international humanitarian law violations. When we speak of international humanitarian law, or IHL, a lot of people also call it the law of armed conflict or the law of war. We speak of a binding legal framework that was specifically designed to regulate armed conflict through basically balancing between military imperatives of states with humanitarian considerations. And thus, it puts together pragmatic and realistic limits to means and methods of warfare. And these limits all try to elevate human suffering as much as feasible. So the purpose of IHL is not to eliminate human suffering, but it's only to elevate human suffering. And this is essential. So, of course, we see that the weakness of arms control at the international level has facilitated, in fact, violations of international humanitarian law as well as international human rights law. It prolonged armed conflict, it hindered humanitarian access, and it contributed to insecurity even after a conflict has ended. So this, of course, has also stalled any attempts at reconciliation and reconstruction, which if anyone lives or works in a region that has been affected by armed conflict, such as the Middle East, they can attest to that. And today, as weapons continue to flow to some of the most brutal armed conflicts, we see that responsible and regulated arms trade is a humanitarian imperative. So restraints on such transfers provided for in the ATT, despite the valid challenges and reservations, are essential to a humanitarian response. And without a doubt, it will help to uphold respect for IHL. So it's very important to note, and as Mr. Fadi mentioned very briefly, there is specific mention to IHL in the ATT. I'll focus on Article 6 and 7. Article 6 also on prohibition. For example, what Mr. Fadi had mentioned, state parties has the knowledge that the transferred weapons would be used to commit genocide, crimes against humanity, or war crimes. Here we see the three international crimes, and we see that there is a knowledge requirement. The actual knowledge, actually knew, or constructive knowledge, should have known. And ICRC's recommendation is this knowledge requirement needs to be interpreted objectively to include what a state party can be expected to know based on the information reasonably available to it. And this is very, very important. I move on to Article 7, which speaks on an export assessment. So it basically proposes that even if there will be no prohibition based on Article 6, so we see that all the criteria are fulfilled in Article 6, that states still have a burden and a requirement for a further assessment under Article 7 of the risk that the arms or items could be used to commit or facilitate serious violations of IHL or IHRL or other serious crimes. This is also very important, where we see that Article 7 limits the target audience to exports only, where Article 6 speaks about all kinds of transfer. But we see also that the wording has a lower threshold of risk assessment. So compared to Article 6, of course. So it is enough that there will be potential, that it is potential that the arms or items that could be used, not just to commit, but also to facilitate violations. So we see that these articles do not only reflect what the international community has agreed on specifically under the ATT in 2013, but it also, in fact, echoes the legal commitments for more than 75 years under the Geneva Conventions. And I specifically refer here to Common Article 1 to the 4 Geneva Conventions of 1949. These conventions have been ratified by all states without any exception. Thus, it makes it a legal obligation, not merely a moral one. So Common Article 1 obliges all parties to the convention, either parties to the specific armed conflict or a third party not directly involved in armed conflict, to respect and ensure respect for IHL. And undoubtedly here, states that transfer weapons are particularly influential in ensuring respect for IHL due to their ability to provide or withhold the means by which violations may be committed. So when we break down this obligation of states to ensure respect, we see two types of obligations as per ICRC's interpretation. We see a negative obligation and we see a positive obligation. So the negative obligation is to refrain from encouraging or assisting a party in any possible way to violate IHL. The positive obligation is to take all appropriate steps to prevent or seize IHL violations. So we see some at the negative to refrain and the positive to actually take steps. In all cases, whether negative or positive, we see that a state is required to assess whether the recipient is likely to use the weapon to commit IHL violations, and also to refrain from transferring any weapons if there are substantial or clear risk violations. So we see that these obligations under Common Article 1 are in fact articulated and reinforced by the ATT, specifically to Article 6 and 7 that I refer to, which not only confirms the prohibitions, but also introduces, the ATT introduces actively mechanisms to ensure their implementation at the national level, such as the monitoring system that also Mr. Fadi had mentioned for regulating arms transfer, maintaining lists of weapons and materials covered by the treaty, record keeping for licenses and exports, reporting, information exchange, and others. It's noteworthy to mention here that currently international human rights mechanisms are stronger and more developed than IHL mechanisms. IHL mechanisms are more limited or are still developing. And through our work and experience in the field, we always see and truly believe that the strongest IHL mechanism is national implementation. And thus, it is vital to have more states integrate IHL, including the ATT, into their national systems. And the ATT, as discussed, does provide some guidance on how to do so. So ICRC has supported and continues to support the Arms Trade Treaty during the drafting and adoption phases in 2012 and 2013, and even after it has entered into force in 2014 to our current day. And also long before the drafting phase, ICRC since the late 90s has called for stricter regulations for international transfers of arms and ammunition. So currently in our bilateral dialogue between states, because ICRC's modality of working is through bilateral and confidential dialogue, we do urge states to continue fulfilling their obligations under the treaty. These are for state parties to the ATT. As for signatory states, we do encourage them to join and respect the essence and substance of the treaty at a minimum. For non-signatory states, we always call them to reconsider this matter. We are very grateful to work to raise awareness about the humanitarian consequences of unregulated arms transfer, along with a large number of states, National Red Cross and Red Crescent societies, and civil society organizations who have been key in the development of the ATT. Moreover, within the scope of our mandate and our expertise in IHL, we do provide a lot of technical support in integrating ATT obligations and principles into national legislation, especially regarding the transfer of weapons based on IHL and IHRL respect. We have published a number of documents to this end, which arms transfer decisions, applying the standards of IHL and IHRL, which, in my very humble opinion, does answer a lot of difficult questions, including indicators that states could and should consider when assessing the risks of transferring arms. So, in brief, this is my intervention, and I would really like to reiterate that in my capacity as a region legal advisor in the NAMI region and in the ICRC, we are more than happy to provide any technical support to any country in our region or beyond. I do believe that it is our shared goal to live this in a safe, sound, and stable region and world, and to reduce human suffering and protect human dignity as much as possible. And this is perhaps what was literally mentioned under Article 1 of the Arms Trade Treaty. Thank you very much for your kind attention, and I give the floor back to you, Mr. Mukhtar.